Neutral and the OECD, it's clear that the momentum is building for change. But yet we see that the deeper structural failures of the ISDS system remain largely unresolved. Investors continue to bring claims that challenge governments' efforts to regulate in the public interest, whether it's protecting public health, advancing climate actions, or ensuring corporate accountability. And so this is particularly relevant now as we see new momentum also building behind mandatory due diligence and also other corporate sustainability initiatives across the world. But key questions remain. Can we truly advance responsible business conduct if the ISDS system continues to shield investors from accountability? So today's discussions will explore that very questions, and we'll hear concrete case studies that shows how ISDS is clashing with sustainability, democracy, and justice, and why we also need to rethink the system from the ground up. So before introducing the speakers, I would like to inform you that the webinar is being recorded and that you can post your questions in the Q&A box at any time, so rather than using the chat. And we will also do our best to address as many of them as possible during the Q&A session at the end of the discussion. So I'm really pleased to be joined today by 4 experts working at the intersection of investment law, policy, and corporate accountability, and who will each bring a unique and valuable perspective to the debates. We have Liz Johnson. Liz is a partner at the international law firm Curtis, where she represents government in investment treaty arbitration and matters of public international law. She also advises states on the development of model investment treaties and the negotiation of international agreements. Liz also brings deep experience from her previous roles at CCSI and ISD. We have also Ladan Mehranvar. She is a senior legal researcher at the Columbia Center on Sustainable Investment, CCSI, where she works on issues related to investment governance, sustainable development, and human rights. And one of her central research interests is the triangular relationship of host states, investors, and affected communities. We have Dr. Stéphanie Triefus. She's a researcher at the T.M.C. Acer Institute, focusing on business and human rights, international economic law, and climate change. And her PhD thesis examined participatory rights and international investment law. She conducted also interviews with local community members affected by the Gabriel Resources versus Romania arbitration. And finally, we have Berghe. Berghe is a senior researcher at SOMO, the Center for Research on Multinational Corporation in the Netherlands, where he works at the intersection of trade and investment policy, climate action, energy transition, extractive industries, and sustainable development. So thank you all for being here and welcome. So let's jump right into our first round of presentation. I will now ask each speaker to briefly present in 5 minutes a case that illustrates really how ISDS has been used in ways that undermine responsible business conduct and public interest policies. So Berghe, let's begin with you. You will walk us through the ExxonMobil versus the Netherlands case. It's a very timely example that touches on fossil fuel phase-out, public safety, and corporate accountability issues. And this case is also linked to SOMO's new report that was released today, and which also highlighted how ExxonMobil lobbying effort to scrap EU due diligence law and other EU climate policies. So I think it's a perfect illustration of how ISDS can intersect with broader strategies to delay climate action. So please, Berghe, go ahead.
Yeah, thank you very much, Amandine. And good afternoon, everybody. It's a real pleasure to join this great panel, this great discussion. So many thanks for the invitation. So I'd like to start by situating this discussion against the backdrop of the climate emergency. So we all know that companies must withdraw from coal and oil and gas, as well as from the infrastructure that supports these industries. Fossil fuel extraction has to decline rapidly if we are to meet the Paris Agreement targets. But just as important as how fast this happens is also how it happens. Without the responsible exit policies, communities are left with legacy pollution, long-term health risks of inadequate decommissioning, degraded ecosystems, and the economic devastation that follows when livelihoods tied to extraction collapse overnight. A rapid closure of fossil fuel projects and a responsible closure are not contradictory agendas. Both are essential for a just energy transition. Now, existing international standards like the UN Guiding Principles on Business and Human Rights and the OECD Guidelines for Multinational Enterprises, they give some guidance for how to responsibly disengage from fossil fuels. They require companies to apply human rights, social and environmental due diligence to any proposed exit. At a minimum, companies must prevent, or where prevention is impossible, mitigate and compensate risks to people and the environment, whether they are selling assets to another entity or whether they are closing projects outright. Not only companies have the responsibility to disengage in ways consistent with human rights and environmental protection, also states have the responsibility to regulate and enforce responsible disengagement, consistent with their own obligations under international human rights and environmental law. But what happens when ISDS collides with this framework of responsible disengagement? And I think the recent case by ExxonMobil against the Netherlands provides a strong illustration. So for 60 years, both Shell and ExxonMobil, in partnership with the Dutch state, extracted gas from the Groningen field, which is the largest onshore gas field in Europe. Over that time, more than 1,600 earthquakes damaged more than 100,000 homes. And residents lived under constant threat with enormous psychological and social impacts. Despite the mounting evidence of harm, the companies, but also supported by the state, continued these operations. And only when a relatively major earthquake hit the region in 2012 did political momentum grow to shut the field. And only when Dutch courts opened investigations into possible criminal liability for willingly putting the lives of Groningen residents in danger in 2016, also the companies started to cooperate. In 2018, Shell and ExxonMobil and the Dutch state signed an agreement that offered the companies higher profit rates in return for waiving their right to sue under arbitration and allowed a gradual phase out by 2030. But when earthquakes persisted, the government announced an earlier closure by 2022. And it's crucial here that there was no clear exit strategy in the original partnership between the companies and the state. So there was no agreed distribution of costs, of revenues, or responsibility for repairing the homes and compensating the victims. So as a result, what we see now is that the disputes over the exit from this gas field is escalating rapidly. So the joint operating company that's operating this gas field, which is called NAM, N-A-M, it launched already 2 arbitrations at the Netherlands Arbitration Institute on the basis of this 2018 agreement to contest damage and home reinforcement costs. Also, Shell and ExxonMobil, as shareholders of the operating company, initiated their own arbitration over the broader wind down of the project, including compensation claims for lost gas revenues, also before the Netherlands Arbitration Institute under the similar 2018 agreement. And last year, ExxonMobil filed a treaty claim at ICSID under the Energy Charter Treaty, which, according to media reports, is focusing on limiting its liability for the damages. And there are also 16 additional legal and administrative proceedings currently ongoing domestically. And meanwhile, the companies have stopped paying for the costs, and they are no longer contributing to regional recovery and development funds. Shell and ExxonMobil are refusing to secure guarantees for future liabilities. And the operating company, NAM, is paying out billions in dividends to its 2 shareholders, Shell and ExxonMobil. And even though details on the international arbitration case are still secret, they are not disclosed, we see that ExxonMobil is already seeking provisional measures in the ICSID case. Again, although details remain undisclosed, we know that in similar cases, tribunals have ordered state to suspend efforts to recover funds or to halt domestic court actions. And this is deeply troubling because Dutch courts have already rejected Exxon's attempts to suspend its payment obligations, finding no imminent financial harm to the company. But an ISDS provisional measures could achieve exactly that, undermining corporate accountability and the domestic rule of law. And to wrap up, this is the broader danger that we see. So ISDS gives fossil fuel companies powerful leverage in negotiations over exiting fossil fuel projects. Even when there is clear evidence of social and environmental harm, companies can use the threat of arbitration to extract compensation, to delay closure, or weaken domestic accountability mechanisms. And this dynamic is basically incentivizing irresponsible business conduct. And finally, this Exxon case shows that ISDS is at odds with the principle of responsible disengagement and with a just transition away from fossil fuels. Because if we want companies to exit in a responsible manner, paying their fair share for remediation, protecting communities, and supporting recovery, we cannot at the same time give them a tool to sue states for enforcing exactly those responsibilities. So thank you very much.
Thank you, Berghe, for this very insightful presentation. I would like now, building on that, to turn to you, Stéphanie, to take us to Eastern Europe with the Gabriel Resources versus Remuna case, which is another example where corporate interests have clashed with the public interests and local communities. And although the events behind the case date back really several years, the tribunal recent decision raised urgent concerns about how ISDS tribunal can overlook human rights and democratic participation, especially when communities resist those harmful investments. So Stéphanie, over to you.
Thanks very much. Good afternoon, and thanks for having me. It's a very interesting panel. Like I said, going to briefly discuss Gabriel Resources in Romania. It was decided in March last year. And it's because it demonstrates how ISDS engages with severely complex social and environmental questions in a problematic way. So Gabriel Resources is a Canadian company that invested in a joint venture called Russian Montana Gold Corporation, RMGC, to develop a large-scale open-pit gold and silver mine in the commune of Russian Montana in Transylvania in Romania. The proposed project would have involved destroying mountaintops, relocating several villages, and using substantial quantities of cyanide in the extraction process. However, from very early on, the project encountered fierce local resistance. Local residents, fearing environmental degradation, loss of homes, damage to heritage sites, including ancient Roman mining galleries, and threats to water supplies, began organizing. So over time, the opposition broadened to include environmental NGOs, students, clergy, academics, civil society, and they united under the slogan, Save Russian Montana. In the autumn of 2013, the protests escalated into one of the largest waves of civic mobilization seen in Romania since the 1989 revolution. Tens of thousands of demonstrators demonstrated in over 50 Romanian cities and in diaspora communities around the world. The Romanian government pushed a Russian Montana law to fast-track approvals and compulsory acquisitions, but public pressure ultimately led Parliament to reject the Russian Montana law. So for Gabriel Resources, this meant that the investment could not proceed. The company initiated arbitration in 2015, claiming that Romania had, over time, blocked or frustrated the issuance of environmental and mining permits and inappropriately designated heritage protections, affecting an indirect expropriation or breaching the fair and equitable treatment obligations. The claimant sought compensation in the order of $4.4 billion plus interest, so it was a very large award for Romania to reckon with. On the 8th of March in 2024, the tribunal issued its award, and it dismissed Gabriel's claims and declined to find that Romania had breached the applicable BATs. But the fact that Romania won the case has already been pointed to by supporters of the ISDS system as evidence that the system works and is not a danger to the public interest. However, one award does not negate the systemic problems or the neocolonial asymmetry of the ISDS system, which has been identified extensively by my colleagues on this panel and elsewhere. And further, a number of aspects of the award mean that it's not necessarily a departure from previous awards that put pressure on government decision-making in the public interest. So just to mention them very briefly in the time allowed. The award was by majority, and so there was a minority arbitrator who would have held Romania accountable for breach of the fair and equitable treatment standard on the basis that the government's actions were political. The claimant is currently seeking annulment of the award, meaning that the dispute continues to drag on for the local community, and it still threatens regulatory chill in circumstances where the threat posed by the arbitration has loomed large over Romania for a decade, and there's been a lot of discussion in politics and the media about restarting the mining project. The tribunal, in its decision, failed to engage with the perspectives of the local community at the center of the dispute and their accounts of the company's aggressive and harmful conduct, despite having heard testimony from a local community member and received extensive amicus curiae interventions. And the reasoning of the tribunal in rejecting Gabriel's claim was somewhat puzzling. It accepted the claimant's argument that composite acts can cause a breach, but then it examined each of Romania's acts in minutiae, and it did not find any of them abusive or unlawful. So, in other words, the claimant argued that the tribunal should take Romania's conduct as a whole and conclude that it failed to act fairly and equitably. And the tribunal said that it would do this, but in practice, it dissected Romania's actions step by step and found each to be reasonable. But that means that a slight change in the facts could have cost Romania the case. And the significance of this is that a tribunal of 3 private arbitrators is reviewing state decision-making processes in extraordinary detail and second-guessing how a government balances environmental, cultural, and social concerns against investor interests. And in this case, in the context of a huge public movement of protest. So what this case illustrates for me is not just a failed claim, but the deep legitimacy challenge facing ISDS. The decisions of immense public consequences are being assessed by private arbitrators in a forum largely removed from democratic accountability, and that pays little attention to the voices of affected local communities. And the underlying dispute arose from one of the largest popular mobilizations in Romania's post-revolution history, a movement that demanded environmental protection, cultural preservation, and participatory governance. Yet in the arbitration process, these broader societal voices have no power. This case therefore raises the question at the heart of ISDS reform, which is, should a mechanism designed to protect foreign investors have the authority to scrutinize and potentially penalize states for responding to democratic protest and exercising their regulatory powers in the public interest? This particular case is not per se a climate case, but these issues of how states have or do not have the space to respond to big public movements is going to be a very important question when it comes to transitioning away from fossil fuels. Thank you.
Thank you, Stéphanie. I think there is a good also connection to the next presentation by Ladan. In a similar vein, your case, the case you're going to present, Prospera versus Honduras, also brings us now to the global south and the issues of sovereignty and democratic oversight over economic governance. And this is one of, I think, over a dozen of ISDS claims threatening to bankrupt Honduras, country which is already struggling to protect its people from climate-related disasters due to debt constraints. It's a striking example of an egregious case raising those critical questions. So can you please take us to the key aspect of the case? And if I can also kindly remind to stay within a 5 minutes time limit. Thank you. Over to you.
Thanks so much, Amandine, and thank you for the invitation and to the other panelists on this call, on this webinar. So yeah, thank you. I'm going to be talking about the Prospera case, which probably most people on this call have heard about. It is a case brought by a U.S. investor against Honduras. It initiated it 2.5 years ago, and it's for about $11 billion. So this is against Honduras, probably one of the poorest countries in the Americas. So it's not just, so what we've heard so far, it's how ISDS and investment treaties are really being used as a sword or a weapon to deter or chill regulation. Sorry, my internet connection is not that great. So deterring or chilling regulation. But this case also shows not just that part of the equation, but also how ISDS and investment treaties can be used as a shield. So baked into legal instruments, whether it's domestic legislation or investment contracts, so that if something were to happen in the future, if there were a change in the regulatory regime, then it would be able to use it as a weapon at that point. So I just want to give some context about how this legal framework came to be. So Prospera is a ZA project, and it's a ZA stands for Zone for Employment and Economic Development. It's located on the island of Roatan off the coast of Honduras. And these zones are or rather were authorized under Honduran law beginning in 2013. Both there was an organic law and there were amendments made to the constitution so that the state can cede sovereignty away from the country and give it to a private entity like Prospera. Now, during this time, it was a brutal dictatorship in Honduras. It was post-coup. They were changing a lot of laws. I think like hundreds of thousands of laws were being passed or repealed. And it was during this time, it was corrupt. It was a corrupt regime, narco trafficking. A lot of the leaders in that government are now sitting in jail in the US. The ZAs is more than an economic zone, a special economic zone. It allows for the establishment of special autonomous jurisdictions that delegate a whole bunch of powers to private entities. They can make up their governance structures, regulatory regimes, environmental matters, labor protections if they want any, dispute resolution, police force, education, everything is up to that special entity, except for some criminal matters and I think international relations. So that's where it was. And the law was controversial from the beginning. An earlier version of the law was struck down by the Constitutional Court because they said you can't give away, you can't cede sovereignty to another entity. Many civil society actors and constitutional scholars challenged both the delegation of sovereignty to private hands and the process by which the law came to be established because it was under this corrupt regime. So knowing that this law was unpopular and unconstitutional, the government, backed by a group of international libertarian ideologues from the US, the EU, all over the world actually, inserted some protections that we see in treaties into the law itself. So, for example, a most favored nation clause into the ZA's law. And then they signed a BIT at the exact same time with Kuwait, which expressly guarantees that the constitutional amendments, the ZA's law, and the related rights shall remain as guarantees for a time frame of about 50 years. So they sort of baked a stabilization clause into this BIT, which now the investor is using to say, well, now that you've repealed the law, which the Honduran government did in 2022, they're saying we're going to rely on the Kuwait BIT and say the lost future profits in the future is guarantees us about $11 billion, which is where that $11 billion comes to be, because they have admitted that they've only spent or they've only had investments that equate to about $120 million, and no one really knows where that money has been invested because there's only one building that's there. So aside from all of that, obviously there's a lot of irresponsible business conduct happening. The communities were never consulted with. They didn't even know that this was happening until they started breaking ground. And it was during the pandemic, 2020. There was a lot of distance issues and everything. And really it shows the difference between the rights that the protections that these investors have through these instruments versus the communities that really are left with nothing but to really go out of the legal system, I guess, to do something. I don't think they're doing anything actually. So I just wanted to say that this case is where you see ISDS being used as a shield and a sword. So it really is incentivizing, as Berghe was saying, irresponsible conduct by companies even before an investment is made. So it's like baked into the legal framework, and then the investment is made, and they're relying on that. And I'll just leave it at that, and hopefully I can come back to other aspects of it. Thank you.
Yes, perfect, Ladan, and you will be able to come back on certain aspects also of the case. Thank you so much. So those were all three really insightful and thought-provoking presentation, really showing how ISDS can indeed act both as a shield for harmful business practices and a weapon to obstruct efforts to advance public and environmental interests. And to close this first round, Liz will now help us zoom out and look at the systemic issues, because those cases are not isolated, but they're really symptomatic of how ISDS and bilateral investment treaties more broadly actually incentivize irresponsible corporate behavior. So Liz, in a recent article, you argued that societal norms, legal rules, and market forces must work together to promote responsible business conduct, and that ISDS disrupt that balance. So could you expand a bit more on how ISDS actually undermine the legal and the market-based incentive for responsible business conduct?
Great. Yeah, thanks so much. And it was great to hear these case studies. It's always really helpful for understanding some of the problems with investment treaties. So well, thank you again also for the invitation. As Amandine mentioned, that my intervention is just based on an article that I wrote a couple of years ago with Lisa Sachs at CCSI and Carol Quaig, a former colleague of ours. And we use different case studies from the ones that we discussed here today, but the themes really overlap. And in this article, we identified that there are essentially 3 levers that we saw that can be used to drive responsible business conduct, but that investment treaties are really problematic because they are fundamentally crippling the power of each. So those 3 levers are: 1, legal mandates. So there's a thing, telling companies what they need to do, what they must not do. 2, normative guidance, so setting directions for companies, even when not strictly enforceable, clarifying, what we, society, expect of them. And then 3, market shaping levers, so using the various tools at our disposal to influence markets, creating them, ending them, adjusting playing fields so as to incentivize or disincentivize conduct. So this issue that we saw with investment treaties is that they were undermining each of these policy levers, and in that way seem to be on this path that's at odds with legal and policy developments in other interconnected fields of climate law, human rights, responsible business conduct. So just to explain a little bit further, so first, with respect to these mandatory legal levers, that companies can and do, and what we've heard today, can and do use treaties to push against them, right? To challenge them or to frustrate their deployment. And this is because treaties have been interpreted as limiting states' freedom to adopt new measures, to adopt new laws, new regulations, judicial decisions, or to amend existing ones, when doing so would too dramatically or too suddenly harm an investor's bottom line or their expectations regarding their bottom lines. So those examples discussed already today and other cases show the treaties allow adversely affected investors to sue states directly in arbitration, seeking declarations that measures kind of upsetting the status quo and requiring them to do something or prohibiting them from doing something, violate international law. But, we know from what we need of responsible business conduct is that the prospect of new legal rules, like shifting away from business as usual, is kind of exactly what is needed in so many contexts, right? Including, but not limited to, climate. For climate, we need new laws, we need new regulations, we need new judicial decisions mandating and driving shifts in behavior. So that's the first issue. And this is also something identified by the IPCC in its assessment report, is that investment treaties, can be used to stall, stop, or shift the costs of these legal mandates. So the second lever, the normative one, this arises because the treaties are sending conflicting signals about what we expect from companies. So instruments like the OECD guidelines and the UN guiding principles highlight and make clear normative expectations that apply to companies, even in the absence of direct legal mandates binding on them. But tribunals and disputes arising under investment treaties have said, in short, that unless the law affirmatively stops you from doing something or requires you to do it as a company, you are expected to think that you can kind of behave as you wish, irrespective of those normative signals. And one case that I think exemplifies this is this case of Bear Creek versus Peru. So there, the government had enabled a project to go forward in a way that was in seeming violation of the human rights of indigenous peoples and in contravention of the OECD guidelines and the UN guiding principles. And when the government later enforced these pre-existing normative expectations against the company to respect human rights, the company sued, and the government was forced to compensate the company for the expenses and problems it had incurred on this foray down a rights-violating, norm-breaching, and harm-causing path. So in this sense, you could see how treaties kind of were used to absolve the business of its own kind of failures to comply with these normative expectations and to anticipate and avoid causing harm. And then third, on this market shaping lever, it's that treaties can be used to reduce or eliminate the losses that would be caused by their own irresponsible conduct. And here I think climate change is a good example to use. The fact that treaties can be used to mitigate investors' exposure to transition risks, the risk that the legal framework will change and restrict their ability to exploit and extract fossil fuels, that weakens the business case for proactive action. So, one argument for why the financial sector needs to align its portfolio with Paris is that not doing so leaves it exposed to transition risk. So in other words, what's safe for the climate is safe for finance. But when investment treaties can be used as a shield or even a sword against climate measures that would strand or otherwise kind of harm the value of fossil fuel assets, the business case for companies to stay away from or reduce their investments in fossil fuels is weakened. So in that sense, you can see how it dampens the market signal. And we also have situations that if investors are able to successfully challenge climate measures, the lawsuits themselves can generate Paris kind of misaligned financial flows, sending money from states and their taxpayers to companies engaged in these climate inconsistent activities. And we saw that through the case of Rockhopper versus Italy, which has been annulled on other grounds. But there, the company successfully used an investment treaty to successfully sue Italy for halting an oil extraction project, and made no secret of the fact that it would use the money that it recovered to develop another oil project elsewhere. So those are just kind of the three areas that we see investment treaties systematically kind of raising problems and creating conflicts with respect to business and human rights. Thanks.
Great, thank you so much, Liz. Let's now move to the second round of follow-up questions to deepen a little bit the discussion. And your last point, Liz, makes me want to turn to Stéphanie to ask whether actually international investment agreements are even compatible with states' duty to protect human rights under international law. So how can states reconcile these two obligations? I know you've also written about how ISDS may have direct and indirect negative impacts on human rights, but also how businesses have an independent responsibility to address these risks through due diligence. So could you perhaps tell us more about this, Stéphanie?
Thank you. Yes, I've argued that for a number of reasons in ISDS is it can cause negative impacts on human rights. And the reason it can be a little bit difficult to talk about these things because the two systems have developed so separately, and that was quite a deliberate choice by those designing the investment law system to try and insulate it from things like human rights. And so when there's no necessarily, you can't point to a particular clash of investment law and human rights law because it is a little bit more insidious than that. But you can definitely identify a pattern where investor rights are prioritized over state regulatory space regarding environmental and public interest issues, which, when you dig a little deeper, then you can end up talking about human rights, like the right to health or environmental rights or indigenous people's rights. So arbitrators don't have to take human rights obligations into account. They tend not to be specialized in human rights or even in public international law and take a very sort of commercial perspective on things. And so what we see as an international society is that it's very difficult to hold corporations to account in relation to human rights. And that fact carries over into international investment law. And I've argued that because of this negative impact on human rights that can be identified in the ISDS system of regulatory chill, essentially, of human rights measures and environmental measures, that businesses have an obligation or responsibility under the UNGPs to assess their plans to bring an ISDS case if that case, has the potential to have impacts on human rights. That sort of legal reasoning is a little bit too complicated to get into in the time that we have, but I'm happy to share that research with others if they're interested.
Great, thank you very much, Stéphanie. This also raised critical questions about corporate risk-taking and who ultimately bear the costs. And I would like to turn back to you, Bartjap, in light of your also knowledge and experience in the Netherlands. How does ISDS actually allow companies to shift the costs of poor or risky business decision onto states, and particularly in climate-related disputes? And how does this actually distort the polluter pays principle that underpins climate accountability?
Yeah, thank you, Amandine. This is a very good question. A lot of it has already been touched upon by the previous speakers, but I mean the polluter pays principle is I mean it's simple, and yet it's very powerful. So in theory, it's the polluter pays principle creates the right incentives that companies are forced to account for environmental risks and impacts in their decision making. So this is in theory, but in practice, we see that the ISDS system risks turning this logic upside down. And that's because ISDS gives foreign investors the ability to sue states in private arbitration whenever they believe government measures affect their profits. And so instead of bearing the cost of their own pollution and their own impacts, companies have used ISDS to demand compensation for lost profits, often amounting to billions. So as a result, we see that environmental and climate measures that should be funded by polluters end up being paid for by the public. And I think, again, this can be well illustrated by a couple of other recent ISDS cases against the Netherlands, related to the Dutch coal phase out. So in 2019, the Dutch parliament adopted a law to phase out coal-fired power generation by 2030. And this was a central part of the Netherlands climate strategy and aligned with its Paris commitments. And the law provided a generous transition period of 10 years, which gave operators time to adjust despite the urgency of reducing emissions. Yet two German energy companies, RWE and Uniper, they responded by suing the Dutch state under the Energy Charter Treaty. And together they sought 2.4 billion euro in compensation for the early closure of their coal plants. And they claimed that this coal phase-out law amounted to a de facto expropriation of their investments, and that it violated their legitimate expectations to continue operating their coal plants for decades to come. Now, even though both companies eventually withdrew their claims, still, I think these cases illustrate how ISDS could distort this polluter pays principles. So first of all, instead of paying for the environmental harm caused by burning coal and the climate impacts, RWE and Uniper were asking Dutch taxpayers basically to compensate them for lost future profits. And secondly, the Dutch coal phase-out law, as I mentioned, it was already very cautious with a lengthy adjustment period. And even if such quite moderate measures already trigger billion-euro claims, other governments might hesitate before adopting stronger or faster climate policies. And this sends precisely the wrong signal at a moment when climate science tells us that we need a rapid and ambitious action. And thirdly, RWE and Uniper made the business decisions to invest in coal plants already long after climate science was well established, and after many countries had signaled the inevitable decline of coal already. So in a sense, these were quite risky investments, and this was also admitted by the CEO of RWE Netherlands himself, knowingly undertaking in the face of climate policy trends. And ISDS now offers a way to offload those risks onto the public. So in short, ISDS flips the polluter pays principle on its head. So because it allows companies to externalize their costs and socialize their risks and privatize their profits, right at the very moment when we most need accountability and responsibility in the transition away from fossil fuels. So I'll leave it there. Thank you.
Thanks. Very, very clear answer, Bartjap. Ladan, a question for you, looking back at your case and others like it. Can you tell us a bit more about how the broader power imbalance between the foreign investors and affected communities, and perhaps also how can states begin to reclaim policy space in the face of this kind of legal and financial pressure from ISDS?
Thanks, Amandine. I'm not going to be able to answer both because of the 4 minute, but I'll do my best. I was just thinking about as I'm listening, the asymmetry, obviously, that is part of the design of this structure. So it's really a binary system where only the state and the investor are in dispute, and the state doesn't obviously always represent the interests of the communities and the public. It has its own rights and obligations, more the obligations, and sometimes the federal government does not actually know what's going on in the location where these disputes arise or where the investment project is. So really, the ISDS is this one-sided tool that allows for investors to initiate these proceedings against the state, and local communities that are affected by the investment project or the dispute have no place in it. So that's the point. There's no access to justice for these communities. I think that access to justice has been even more exacerbated these days because of third-party funding. So third-party funders come and fund these investors to bring these claims. And so local communities, like, where do they get any sort of legal costs and stuff? So one aspect of this that people turn to, and they say, well, there's at least, amicus submissions that can be introduced into the proceedings by affected communities. But we've seen time and again that these amicus submissions, not only are they rejected by the tribunal, but when they are accepted, they're really minimized and ignored. They're given very strict limitations. They say you can only talk about this and you can only talk about that. And I was thinking about the Gabrielle resources one, where the tribunal says it has serious doubts that the amici would bring a new perspective to the proceeding, even though the communities were central to this dispute. And it says that the tribunal expressed doubts that the amici had a significant interest in the matter. And this happens all the time, but they allowed the amicus submission, but given all of that, and then they said you can only have 5 pages and you can that, it really becomes just the fake way of allowing something to come in, at which they really don't take into consideration afterwards. The other thing about these different sort of obligations, when there are human rights violations, and I'm thinking about the Copper Mesa case in Ecuador. In Copper Mesa, if you remember, there was even footage in a documentary where they showed all the violence that was initiated and instigated by the private firm that the Canadian mining company had hired, and they saw all of that, and they said the tribunal, when they were analyzing the obligations owed by the state to the investor, they said, we recognize that the government in Quito could hardly have declared war on its own people, yet in the tribunal's view, it could not do nothing. So according to the tribunal, then Ecuador had not done enough to assist the investor, even though the people of Ecuador were being repressed, they were being killed. So really, it implies that the central government's duties to a foreign investor can and should override the role and protection that's granted to its own citizens under the Constitution and the express views of local governments and communities. And just maybe lastly, I just want to say how ISDS decisions also tend to undermine any other decisions that communities may get from regional or domestic courts. So the best example of this is the Chevron case, again, in Ecuador, where the Ecuadorian court ruled in favor of the plaintiffs and against Chevron, and it was a multi-billion-dollar claim. But then when Chevron took it to ISDS, the ISDS tribunal, in its judgment, it ordered Ecuador to remove the status of enforceability from the judgment, from that domestic judgment, and to preclude any of the plaintiffs from enforcing any part of that domestic judgment. So even if you get some sort of a victory domestically or regionally, these ISDS tribunals can come and undermine that and say, well, if Ecuador does that, then whatever, 1, 2, and 3 will happen. So yeah, that's where my access to justice issues come in. Thank you.
That was really great, Ladan. In 4 minutes, you managed to cover a lot and provide a lot of great response. I have one more question before opening the floor to the audience. And I said that actually my question is similar to the one that someone posted in the chat. So for Liz, so there's been an interesting recent investigation by Follow the Money, from August 2025, showing that oil, gas, and mining companies, they filed like a record of 22 exit claims this year alone, and directly targeting climate-related measures. And what makes this trend particularly alarming is, has been also discussed before by all the panelists, that tribunals often take a narrow view, prioritizing investors' rights and expected profits without really fully engaging with states' broader legal obligations, like protecting human rights and meeting climate goals. And so if the current tribunal practices continue, this is going to significantly undermine those public interest regulation. And in this context, could the recent International Court of Justice advisory opinion on states' climate obligations actually shift how tribunal approach these cases? What potential do you see for international law also to recalibrate the balance between investors' protection and urgent climate and human rights imperative?
Yeah, I mean, I think it's a great question, and I definitely will only be able to kind of scratch the surface of an answer given kind of how much is in that decision and then how much is underlying it. But I think maybe 5 quick points, and I'll keep an eye on the time. One is that I think it's interesting that the issue of investment treaties was expressly flagged in written and oral submissions to the court, and then Judge Cleveland also addressed the issue in her separate declaration, where she said that the interpretation of investment instruments must be informed by states' obligations in respect of climate change under international law, including the stringent due diligence standard to which states are bound in implementing such regulations. So there, the connection between these different spheres of law has been kind of reinforced. Second, the ICJ decision focused primarily on this role of states, but that also included a reference to their role in regulating the conduct of private actors, including by prohibiting certain forms of activities. So now I think that should influence the expectations and behavior of those private actors, which we know can be relevant to interpretation and application of investment treaties. Third, I think to build on what Stéphanie said earlier, which I think is a really important point, is that I think companies, third-party funders, lawyers, and arbitrators have their own responsibilities under both principles of responsible business conduct and their own relevant rules of professional responsibility to really understand this decision and the underlying issues and what it means for whether or not they should bring the cases in the first place, and if so, what they're arguing, and for arbitrators, how they are approaching and deciding these cases. Fourth, and I think it's related to that third point, is I think you can find in the ICJ's decision support for this idea that home states, the states where many of the multinational companies that are using the treaties are headquartered, have their own obligations with respect to how the companies are seeking to use the treaties, and should take action to ensure that the treaties are not used in ways that undermine those home states' own obligations under international law with respect to human rights or climate change. And then fifth and finally, I think we need to make sure that this focus on ensuring investment treaties don't stand in the way of climate action is not the only focus, right? It's important, but the problem is bigger than that. And we need to make sure that investment treaties aren't used by companies to also steamroll over human rights, environmental protections, access to justice, et cetera. So I think that the ICJ's decision does have language useful in that regard, but those aspects of the decision also should be elevated and used. Thanks.
Thank you, Elise, for trying to answer that difficult question in 4 minutes. We have now more than 15 minutes for answering questions. I see 2 are in the Q&A box. I will start by maybe taking the one from Mathilde Dupré, who has been referencing the case brought by several groups versus France, where you've tried to submit an amicus curiae, but it seems like organizations in Guyana have been the only one authorized, and that you were told by the tribunal that they could be potentially liable for costs. And your questions is whether that position on the costs for amicus curiae is a standard practice, and which doesn't seem to be. So I will maybe ask Ladan perhaps to comment on this, or perhaps Lise. I don't know who of you would like to answer the question.
Yeah, I think that Lisa might be a better person to think. I've heard that this has happened, and it can happen. I think it's pretty egregious that that's what has happened because it shouldn't happen. And I think that uh, the states have a responsibility to say something in their submissions that that should not happen. I've actually spoken to the U.S. government about this, about some of their cases, and because they bring a lot of non-disputing treaty submissions themselves when their investors are suing other countries. And they were pretty surprised that tribunals are putting this cost order on communities for bringing an amicus submission. And we were discussing how they can also submit that shouldn't happen. But I don't know much more other than that. So maybe Lisa knows.
I mean, I agree that it's rare. I think I heard of another example where a tribunal had ordered the EU to make a cost submission when it was making a submission in one of the intra-EU cases. And then ultimately, I think that the EU decided not to make a submission based on that fact. So you can see how it would definitely have a chilling effect if it discourages even the EU from doing that. But it's interesting that was also done in this, interesting and unfortunate that it also happened in this case. I think in the UNCITRAL reform discussions, this issue came up and states pushed against it, thinking that this is actually inappropriate because it would definitely discourage amicus participation.
Thank you, Liz. There is another question in the chat on, well, how do we measure non-binding instruments such as the SDGs influence and interpretation and implementation of IIAs, so international investment agreements, and what are the flexibility in interpreting sustainable development across different treaties actually strengthen or weaken its effectiveness as a legal concept. Would anyone would like to answer that questions? I was thinking maybe either you, Stéphanie, Ladan, or Liz, or the three of you.
I don't have a particular answer to this one. I think maybe that the fact that I can't think of any tribunals discussing the Sustainable Development Goals is indicative that that is a big silence in international investment law. Although obviously the term sustainable development does appear in a number of bilateral investment treaties. Again, I can't think of many tribunals discussing this issue. I don't know if that lies on me or if that is a finding about the system itself.
Thanks, Stéphanie. If Liz and Ladan do not have anything to add, I have maybe one more question from the audience, which actually relates to whatever I was also thinking to ask each of you. So actually, yeah, based on this discussion, what is the single most promising avenue for ISDS reform in the panelists' views? I think it's a great question. Also noting that next week webinar that Lucas Shog from ISD will be moderating at 1 p.m. Is also going to go deeper into the reform options that are on the table and those who haven't been explored yet. So maybe we can do a quick tour de table for each participant to express a little bit, what would the new or unexplored reform options do they see as most promising? Maybe we can start with you, Ladan, and then Liz, Bartiap, and Stéphanie.
I mean, I think the only option really is to exit. It's to terminate these treaties and leave ISDS behind us. I mean, ISDS is investor state dispute settlement. So maybe I don't mean ISDS, but I mean this sort of arbitration system leaving behind us, and really rely on domestic remedies or state to state if that happens. I think the reform processes that we've seen either at the bilateral level or the multilateral are not meaningful or effective. Lisa and I were just at the UNCITRAL Working Group 3 negotiations last week, and it's just the same. Nothing is really being changed. And there is this power asymmetry in the room where the global north are really, again, dictating what the new reforms, and I say in quotes reformed because it's really not a reform, it's more codifying the status quo, is in these treaties. And the global south countries really just have to abide by it. And obviously, global north countries are no longer really bound by these because they've either exited from their treaties between each other or they are going to in the next few years. So yeah, I think the only reform option is to terminate these treaties for good.
Thank you, Ladan. Liz, over to you.
Yeah. Well, actually, can I quickly go back to the SDG question because I think it's a good one,
Sure.
and I just think, I'm sure we've all spent time, and certain people spend time thinking about how you could interpret treaties in a better way. That they are so vague, you don't necessarily have to have this awful outcome from them, but unfortunately, that is what we keep getting. And even just with the idea of the definition of an investment, and that how some tribunals in the past had said contribution to the development of the host state should be a criterion. And a recent decision I was looking at where the tribunal said, well, no, we can't do that. That's too complicated. But you could use the SDGs as a guide for bringing that in of what is contribution to development. But tribunals just keep shying away from that. So I have, I think, over time lost faith in that approach of kind of relying on better interpretation. I agree with Ladan. I think the best way of reform, I'm not sure if it's the most realistic, but I would say withdrawing from ISDS, so withdrawing consent to ISDS and having disputes resolved in a different manner through recourse to domestic courts or state to state. So that would be my preferred outcome. Thanks.
Thank you, Liz. Marcia, do you agree with Ladan and Liz, or do you have a different opinion?
No, I don't have a different opinion. I mean, I think there's so much at stake, and I think the challenges that governments and that societies are facing are pressing at the moment, that we cannot afford relying on these long, prolonged reform processes with very uncertain outcomes. So, I mean, the most acute problems with the system of ISDS, they arise from the current investment treaties that we have in place now. So I would also agree with the previous speakers that we need there is a fundamental need to address the current treaties, because all of these ISDS cases that we see, they arise under these old treaties. So I think the best way forward is indeed to think about termination, preferably in a coordinated, multilateral manner, or other options like withdrawal of consent to ISDS. Also to make space and make room for proper alternative approaches to arise, and that will require more time, of course. But you need to have that policy space to allow you to develop new models. There was one additional thing that I wanted to add. It has been touched upon already, but I think ISDS is not only embedded in investment treaties, but also in investment contracts. So I think also as more states are withdrawing from treaty-based ISDS, there is a real risk of a shift towards the contract-based disputes. So coming back to the case of ExxonMobil versus the Netherlands over the closure of the Groningen gas field, 3 of the 4 arbitration cases actually stem from very specific agreements between the companies and the Dutch state, where there is an explicit consent to arbitration instead of going to domestic court. So I think also states should ensure in their contracts that disputes are being resolved in domestic courts, and their contracts are governed by domestic law. I'll leave it there. So thank you very much.
Thank you, Bertha. Stéphanie, a last word.
Thanks. I can only echo my fellow panelists in some pessimistic sort of approach to reform questions, because the system is so fundamentally designed to be asymmetrical, to be oppressive of the global south and local communities, that it cannot be tinkered with in order to make it better or to make it functional, and if you consider to be respect for human rights and the environment to be functional. I think I would definitely echo what Berghe said about the danger of abolition leading to an even more secretive system involving just state contracts rather than this modicum of publicity that we have around ISDS. And I also want to emphasize that if we're also only talking about dispute resolution, then we're not going back far enough, because investments need to be governed from the beginning in a way that respects human rights and the environment and local communities and indigenous rights, and not only start considering these issues when we get to a dispute. And also discussing the ECT and this, we have a bit of an example of this exit of this of the ECT, but then what you're seeing is an incredible hypocrisy that Europe is trying to cancel out these treaties for itself, but then it's still actively going out and agreeing to treaties that will allow European companies to continue to put pressure on global South states. So these are all issues that we need to be alive to in this reform debate. And I wish there was something more positive that I could say, but that's the state of things at the moment. Thanks.
Thank you so much, Stéphanie, and thank you to all the panelists and also everyone in the audience for that powerful and eye-opening discussion. I think we've heard today, what we've heard today is making one thing very, very clear. ISDS is not just a legal mechanism, it's clearly a political and an economic tool that really shapes who gets protected and who gets left behind. And I think the last also round of comments from the speakers are great to transition to next week webinar. And I know that there is an additional question in the chat, but I think it's going to be also addressed next week in the next webinar, really looking at what are the other also option if there isn't sufficient political will to execute an exit from ISDS. Reform efforts are underway. We heard today that, well, and we'll hear more next week, but there is a clear risk of tinkering at the edges while leaving the core structure imbalance intact. So the challenge that we now face is bigger than the technical fixes, and we need to start imagining really real alternatives and one that really prioritize public interest, human rights, and sustainability over investors' privilege. So that was just the start of our discussion. Thank you so much, everyone. Do not forget to register to next week webinar. Again, a reminder, it starts at 1 at 2 p.m. CET. And it will be moderated by Lucas Schorg, and he will also explore, well, why the current efforts are falling, what are moving, and what moving beyond also ISDS might look like. So thank you all for being here, and a special thank you to our brilliant speakers, and we hope to see you next time.
Thanks very much, Amandine.
Thank you.
Thank you.